All rise. The Court of Appeals Division 1 is now in session.
You may be seated. Good morning. We are here for oral argument in case number IC220030, COBURN versus Larry H. Miller. We record and live stream these proceedings, so please give your name and the name of your client when you begin. You have a maximum of 20 minutes per side, although you are not required to use all of your time. You are responsible for keeping track of your own time, including any amount of rebuttal time you would like to reserve. Please keep in mind that we have read the briefing, studied the record, and discussed the case in conference. Counsel, you may proceed.
May it please the court, my name is Eric Auerkamp. I represent the petitioner, Mr. Dennis Coburn, who's seated back in the audience today. This is a case on special action from the Industrial Commission concerning the establishment of the average monthly wage. The average monthly wage is a critical number in workers' compensation cases. That number determines the benefits that an applicant's going to receive for the rest of their life when they have a permanent injury. Therefore, although we may only have a $417 difference, that adds up over time and is a material difference in a case like this. The average monthly wage has been defined and its role defined by the Arizona Supreme Court in the Lowry case. It is to represent an applicant's earning capacity, not just actual earnings, but
Counsel,
earning. Yes.
Let me interrupt you for just a moment. In this case, it seems that both parties agreed that a deviation from the presumptive 1 month, the month of injury, was appropriate, and the ALJ deviated from using the month of injury earnings as the wage to calculate the average monthly earnings. But what is the basis for that deviation?
If we go back to the definition of average monthly wage as set out in the Lowry case, it's to represent their earning capacity. I don't know of a single Arizona case that says a judge can use a non-cyclical time period or a time of temporary reduced earnings to lower someone's earning capacity and to bring that number down. As a matter of just generality, we have that 30-day presumptive period. Because for many waged hourly workers, if they worked full-time and you look at their 1 month before the injury, that's their current wage. That's their current earning capacity. It's sort of a presumptive. But if that's not representative of someone's earnings, you then go to an expanded period. In this case, both sides looked at it. That 30 days really wasn't representative. Yet, a point I was going to make later in argument, when the ALJ in this case determined the average monthly wage, that presumptive time period that both stepped past, she incorporated and used that in the calculation, which doesn't make logical sense. In Arizona, we have the Wozniak case. I like that case, and there's a quote out of that case I want to read to you because I think it's very instructive and it focuses us on that average monthly wage and how it's determined. It starts out and it says, again. I'll pause there at that word because...
Will you give the site, counsel, as you read it?
Yes, the Wozniak case, and the specific quote is in the brief. Let me get
It's 238 Arizona 270.
Thank you. It starts out again because the court's making the point, this isn't new law in Arizona. This is the standing law, and they're going to cite the Arizona Supreme Court in Pettis. And it says, we agree with the announced law that we're giving during a given year, They're not just taking a small period, as some of the cases will throw out and say, well, he was on vacation during this time, we're not going to average that in. There's something that happened. They're expanding this out, saying for a whole given year, an injured employee loses time due to events over which he has no control. That's the first point. And where the loss of time is not a common and ordinary incident. This isn't what typically happens. So if something that's not common and something that he doesn't control, says is not common or ordinary incident to the particular employment, such time should be omitted in computing his average monthly wage. Now it's important. Opposing counsel is going to make a big point of you give discretion to the ALJ. But if you look at every one of these cases, all these cases on average monthly wage, the discretion to the ALJ is given for them to step aside from bright line rules or time periods to get to the true earning capacity of the injured worker, not to pull it down. This is a great case for appeal because we have a very tight fact pattern with limited evidence.
Counsel, before you proceed, can you clarify for me what exactly was the time period that Mr. Coburn was requesting? Because and some seem to say it was 2019, but then it wasn't 2019. So can you just clarify that for me?
Yes. The time period is not defined by any of the cases. You go to an expanded time period till you get to true earning capacity. Mr. Coburn presented evidence of his wages from 2016 all the way up until the date of injury. In 2016, Mr. Coburn was a max wage earner. That means his wages were higher than the maximum wage that could be considered by the Industrial Commission, and they cap it. In 2017, his wages again were a max wage earner. In 2018, he was a max wage earner. In 2019, he was a max wage earner, and in fact, his wages were more than $20,000 more than the cap. Then 2020 hits with COVID and the supply chain shortages, and his income dropped by 1/3. In preview, that's the time period the judge took, along with the 30-day presumptive, to calculate and state this is his average monthly wage. He had a work history proven. And what we like about this case is Mr. Coburn has been working for this employer for 25 years as a transmission mechanic. We don't have other variables in here. He is a solid max wage earner year after year after year. Mr. Coburn explained why his income dropped in 2020 when COVID hit. He went to fix transmissions and he could not get the parts.
But the ALJ did not find that testimony credible. Is that right?
Exactly. In fact, the judge said all the testimony was baseless of both the defense witness.
Well, was it all or the explanation for why the difference between the wages earned in 2020 and 2019? Just that point.
There's not a finding that's clear on that, other than she references the testimony and says this is baseless.
She says, paragraph 10, the records show applicants' wages were less in 2020 than 2019, but no convincing evidence was submitted to establish why his salary was less in 2020 than 2019. Applicant opined it was due to the pandemic and the shortage of parts, and England opined it was due to DPS warranty work ended. There is no basis to accept one opinion over the other, and there was no good basis provided for the opinions. But that's specifically speaking to the difference between the wages earned in 2020 and 2019 and why they dropped in 2020.
And that was the focus of 90+% of the testimony in the case. It's just an average monthly wage case, that one narrow issue, and she threw that out. Said it was baseless. She didn't have foundation for it.
Can we, just so that we can keep it in order of the points that the bench is concerned about here, what would be the basis for deviating from the standard, the presumptive 1 month of injury?
The judge has the discretion to deviate under Lowry from any bright line rule, either whether it's the 30-day or a year or going back further. Anytime there's a time period of economic depression or something that's non-cyclical and out of the control of the worker.
Right, but my question is, in this case, what was the basis for that deviation? We understand there's discretion to do that, but in this case, where do we find the support for that deviation?
It was the explanation of both Mr. Coburn and also the admission by Seth England, the defendant's witness, that there were supply chain shortages. Seth England, in his testimony, admitted there were supply chain shortages. He said, I think his quote was, "I cannot deny that."
But I thought the ALJ rejected those opinions.
So she rejected it all. What does that leave us for evidence? It leaves us the payroll records. We got payroll records in evidence. She's thrown out all the testimony on that issue. We now have 4 years of payroll records showing he's a max wage earner all the way until the pandemic, with a 30%, a one-third precipitous drop in wages, and that's the one that was picked.
Is it enough for the ALJ to find a deviation was warranted here because both parties seem to agree that a deviation was warranted? Would that be a sufficient basis for that deviation?
Absolutely, both on a couple grounds. First of all, the judge, both sides stepped aside from the presumptive because it wasn't going to be accurate. But the judge utilized that time period in the calculation. In other words, the well was already poisoned. We have a time period that both sides are saying, this isn't representative. That was taken and included in the time period the judge used. And then she used the rest of that COVID time period to come to this artificially low number, which is proven that the strongest evidence in the case is the man's work history of proven wages, and that's not contested. He has this max wage earner going year after year after year. He's 20,000 above it until he hits COVID and it drops. And with no real finding other than it's not persuasive or it's baseless. And in the Aguirre case, just because it's declared so doesn't make it so. There's no explanation, there's no findings as to how did the judge throw all that out. She then, because the only thing she's left with now is the wages and the record. The wage record proves the earning capacity. So we don't have any testimony on it. All we have is the wage record, and then the judge decided to go with the COVID time period.
Just so I'm clear on your position, in your brief you say the ALJ did not make sufficient findings to support her decision. Are you saying that goes to both deviating from, she didn't make sufficient findings as to the deviation, making the decision to deviate from the presumptive wage base, one, and her ultimate decision to come up with a particular deviation?
All aspects of that. We don't have a reason as to why she deviated off it. We don't have a reason as to why she determined baseless testimony. We have a 25-year mechanic testifying about wages and the supply chain problems. We have the defendant's expert, and neither one of these were objected to when they testified on the record. The manager came in and said, this is the presumptive. Or sorry, I misspoke there. There's no question there's a supply chain shortage. How did she throw that out as baseless?
Well, but he said there's no question there's a supply chain shortage, but he had other work that he could be doing so that the shortage wasn't affecting his wages. Isn't that more
that's what he
a
started.
fair statement of what was testified to?
You're correct. But if you look into that evidence a little bit better, and the reason it was backed off, first of all, he tried to point the finger at the DBS 6 warranty, this Ford warranty that was profitable. He had available to him the information as to how much income was attributed to each mechanic from that warranty. They decided not to put it into evidence. They controlled it and didn't do it. Therefore, there was no evidence for him to say that. In fact, that
Counsel, the credibility determinations are really, that's the ALJ's province, correct?
Yeah, but the judge didn't say it on credibility. The judge knocked it out as just being, quote, baseless. And we have the judge with these DBS 6 warranties. When they went into it, the DBS 6 warranty had been fading out for years. And in every year up until the pandemic, the applicant's wages had increased, not decreased, with the fade out of that warranty. So the argument started to fall flat. One of the reasons that evidence was never actually put in. In fact, that's the one objection in the record that was sustained. I said, they can't testify that that affected his wages. His wages are going up. Also, this mechanic was known in his testimony for working on older transmissions. He's been a transmission mechanic his entire career, 25 years just with this one employer. And he worked on other brands. And there was no evidence at all in the record as to how much of a DBS 6 warranty income affected him. In fact, the other two mechanics they showed, their income didn't drop, even with that same DBS 6 warranty. So the evidence wasn't there, and that argument, that was a red herring. They made that argument, but it never proved out, and the evidence was never put in. So what we have is two areas of concern for this appeal. One is a decision that came down that's disregarding Lowry, Wozniak, and Pettis. Those cases, the judges are given great discretion, but for what purpose? To get people's average monthly wages up to the correct level. With this man, he had a proven history. Then she took the one period that's down low, but she threw out the evidence, all the testimony on it. Why? And what evidence does that leave her with? We have a proven history. She picks the 1 year to go low. Next, there's no findings for us to figure out, why did this happen? Why did they do it? It's directly contrary to the Wozniak case and to the Pettis case and to the Lowry case. So we feel the decision is directly contrary to the law. Unless there's other questions, I'd like to reserve the rest of my time for rebuttal.
Thank you.
Thank you.
May it please the Court. My name is David Lundmark, and I represent the respondents, Larry H. Miller Management Corporation and WCF National Insurance Company. The petitioner hopes that by crying COVID, he can escape the presiding judge's straightforward determination of his average monthly wage. But the presiding judge was correct. She properly exercised her discretion as trier of fact, and she correctly determined his average monthly wage based on his earnings over the year before his injury.
So, counsel, let me ask you a question that your colleague is arguing. In paragraph 10 of the ALJ's order, she states there's no basis to accept either the applicant or England's opinion over one another. There's no basis for either. So if testimony on the drop in income from 2019 to 2020 is thrown out, what are we left with? Your colleague's saying all you're left with is to look at the history of payroll.
So what the judge threw out was the testimony regarding the reason for that drop in income. And the petitioner contends that that was an error on the judge's part, but really the judge was right to decline to resolve this conflict in the testimony. She didn't have any reason to resolve conflicting testimony about why his wages dropped from 2019 to 2020. The petitioner's position is that his wages were artificially lower because of the COVID-19 pandemic. But assuming we're going to apply this expanded wage range, the 1 year before the injury is sort of the natural period that...
Let me interrupt there.
Yeah.
Assume we're going to apply the expanded wage range.
Good.
Don't you concede in your answering brief that the presumptive 30-day is, you're not asking for that?
No, we're not asking for that.
So your position is, your client's position is, the expanded wage range is appropriate here. The question is just which range are we using, correct?
That's correct.
Okay.
Yeah. As a matter of standard practice. Well, maybe not even standard practice. Under ARS 231041, the average monthly wage needs to be set to reflect the applicant's earning capacity at the time of injury. So there's a presumption, as you've acknowledged, that the 30 days of continuous employment before the injury will be used to set that average monthly wage. But if there's some reason that those 30 days are not going to give an accurate picture of his earning capacity, the judge will use an expanded date range.
What is your client's position for why those 30 days are not reflective of his earning capacity?
Your Honor, I don't know the answer to that. I know that the parties stipulated that the 30 days would not be accurate.
Well, there wasn't a stipulation per se. They just advanced positions that supported that.
That's correct. And his earnings for that 30 days previous were even lower than they would have been if the year before had been taken into consideration. And so, based on my review of the record, there's not a clear answer to that question, but I think there was a sense that those far depressed wages for that 30-day period was not an accurate picture, and that the year before the injury would give a more accurate picture of his...
All right, so let's get into that portion because I'm very curious about the answer. What is the support for the proposition that the year used by the ALJ is the appropriate reflection of his earning capacity?
Well, the standard is not to apply any particular time frame. There's not a bright line rule.
Right, but it can't be just...
It can't be anything. That's right. And as a... So say the basic principle, as I mentioned, is to determine the earning capacity at the time of injury, not the earning capacity 2 years before the injury, not to speculate on what the earning capacity might be 2 years after the injury, but at the time that the applicant was in fact injured. And so the closer you get to that period of injury will give you a more accurate picture of what the earning capacity was at the time of the injury. A 1 year period, granted that's 12 months, that might be a little long, but that does give an expanded range to kind of even out, to smooth out the highs and lows that might fluctuate over the course of a year and give a good average picture of the earning capacity. That's not always the case. In the Floyd Hartshorn Plastering Company case, that's 16 Arizona App 498, there the presiding judge used 8.5 months before the injury. So there is some flexibility. This is within the presiding judge's discretion to determine what expansive time will give an accurate picture of the earning capacity, again, at the time of the injury. And here the judge decided that it was the year before the injury. Now, Your Honor, you asked why the judge, I think your question was why the judge felt she could ignore the opinions or rule off as baseless the testimony regarding the reason for the drop in 2020. And
No, I don't have a problem with her doing it. I think it's within her discretion to do that, weigh credibility in essence. But my question was more, what are we left with then as far as evidence to determine what the earning capacity was? But while you're thinking about that, can I ask another question?
Yes.
So you'd indicated that your client's position is that this year that the ALJ used was within her discretion, correct?
Correct.
Calculate the extended wage period. But if your client's position is that the last 30 days was low, was not an accurate reflection, if they've already reached some agreement or advanced some position, the parties, wasn't it error then for the court to at least use that month in its 1 year calculation? Are you following me?
Yes, I am. The answer, I think, is no, and that's because that month on its own might not have been sufficient to set the average monthly wage. But looking at the wages over the course of the entire year would enable the judge to smooth out, again, those months where the earnings were a little bit lower than average, and those months where the earnings might have been higher than average. There's been no finding that the earnings those 30 days before the injury were so abnormally below average that it should be thrown out altogether. And in fact, under the case law for omitting periods of time in calculating the average monthly wage, all of the cases that have addressed this deal with situations where the employment has been intermittent or seasonal. The petitioner referenced the Wozniak case that was dealing with a ballet instructor who had seasonal work and whether the court should omit periods of time where he didn't have work. There simply aren't cases that talk about omitting work where the applicant simply has lower wages, even though he's working on a full-time and continuous basis, which is what we have here.
Would it have been error if the court had used a 5-year period, 2016 to 2020? Would that have been error?
Under the facts of this case, yes. I don't know that I can answer that question in the abstract. There might be some reason why that would kick in. But I think the answer is yes, probably in almost every situation. Again, we want to determine the earning capacity at the time of injury. You might say, well, why not take his lifetime earnings, going all the way back to when he got his first job at the movie theater when he was 13. And I think that's going to be too far, and it's going to cause too many fluctuations. Again, the closer you can get to the earnings at the time of the injury is going to give you a more accurate picture of what his actual earning capacity was when he was injured. So, 8.5 months, 3 months, a year, all of those are within the judge's discretion. Could she go beyond that? I suppose she does have the discretion to go beyond that if there's some reason to that's indicated by the evidence. I don't think that was indicated here. The judge made a pretty straightforward evidentiary determination in this case. There was some testimony that the petitioner's wages were depressed because of the COVID-19 pandemic. She found that there was no foundation for those opinions and was right to exercise her discretion to therefore disregard them. Having disregarded that testimony, she had no reason then to reach the employer's testimony for another explanation for why the wages went down. The evidence that she had was simply the fact of the applicant's wages during that year. And she determined that those fairly represented his actual earning capacity at the time of his injury, which was well within her discretion. Unless there are any further questions, Your Honors, that's what I have. Thank you.
Thank you.
In this case, the question is really simple. What's this man's earning capacity? He has years of max wages, year after year after year, as far back as we could get his payroll. He's over the max. In 2019, he's more than 20,000 over the max. How far back can you go? The Wozniak case is clear. In that case, it wasn't just seasonal. It says during a given year. In the Wozniak, the court says if you got a year, whole year time period that doesn't look representative of someone's earning capacity, you can omit it from the calculation and it should be omitted. Other than that 1 year, which included that time period, and by the way, the answer to the question is Mr. COBURN was on vacation for the month, during that month before the injury, and therefore his wages were artificially low. But you're correct.
Is that anywhere on the record?
It is. It's on page 27 of his testimony.
In day 1 or day 2? That's fine. I don't want
You
to
have
use
the
it.
transcript right here if you can grab the date on that
That's
testimony.
fine. I have it too. Go ahead.
Okay. And therefore, that time period's poisoned, agreed by both parties, it's non-representative, yet that's then included in the 1 year with a complete disregard of earning history. We think that is judicial error and contrary to Wozniak and Pettis and well-established law in the state of Arizona. Nowhere is there a case that says the judge should take one time period artificially low, use her discretion to pull someone's earning capacity down. There was no other change that was brought up that was substantiated with any evidence other than COVID. This man has a long period of max wages. One other item is the judge determined that that testimony from the two witnesses lacked foundation. Procedurally, she sua sponte raised that foundational argument after evidence with no objection by either party, giving no party the opportunity to cure the foundation if there was a foundational error. I still don't see the foundational error in that testimony. Both of them have decades of work experience and clearly understood the market and the supply chain shortages in their industry. The applicant worked 25 years for this employer and years before that for other employers fixing transmissions, had never seen this kind of supply chain shortage before. Mr. Seth England agreed he had never seen this type of thing before, and he could not deny there were supply chain shortages. Just in my last few seconds, why did his income come down? Because whenever a transmission didn't have a part, he had to wrap that transmission in plastic. He then had to take all the parts, set them aside. They had to push the vehicle off the lift without an engine, park it. He then has to call the customer and explain why their car's not going to be done. Then when the parts come back, he has to retrieve a car and put it back on a lift and put it up. He then has to bring the transmission out, unwrap it, reset up his work area, and he's a flat rate employee. He doesn't get paid time, he gets paid by the job. Thus, his income during that year plummeted.
Thank you for your arguments, counsel. We will take this matter under advisement and issue our decision in due course. This court stands adjourned.